You're watching Public Affairs. Berkowitz is my name, and politics is our game. And we will be doing politics this evening because we have as our guest Professor Stephen Presser from the Northwestern Law School. He has a joint appointment there in law, in business, in history. So he's a triple threat, so to speak. We're obviously going to be talking, not obviously, but we're going to be talking about Judge Sonia Sotomayor, who, of course, has been nominated to the Supreme Court. And you might say, Berkowitz, you do politics. Why are you doing that? Well, the Supreme Court listens to the election returns. Let me tell you, there's a lot of politics that goes on getting on the court, what comes out of the court. It's maybe law, maybe politics. We'll find out from our guest, Professor Stephen Presser. And before we do, let me just go back a bit. We're taping this on May 31st, 2009. Let's go back to July 24th, 2003. Sitting in the chair just to my right, not necessarily to my philosophical right, at that time was Barack Obama. And he was running for the U.S. Senate. And we asked Barack about judges because that was, we sensed, could be a very important thing coming down the road. And just think, in less than 6 years, Obama went from a U.S. Senate candidate, 8 months later, just killed the opposition in the Democratic primary, thought it would be a tough race. Blair Hull spending $39 million. Danny Hines, the son of Tommy Hines, big political family, 4 other candidates. And Barack blew it all away with 55% of the vote, won the general election easily against the unlikely candidate, Alan Keyes, as a U.S. Senator, 2 years in the U.S. Senate, and then he's running for president, and then essentially blew away Hillary Clinton, if you will, to become the nominee of the party, and then blew away John McCain. And here we are 6 years later, and people are talking about, can Barack Obama change the Supreme Court? Can he have a dramatic impact on this country by changing the composition of the court? And lo and behold, he gets an opportunity perhaps sooner than he might have thought. He nominates Judge Sonia Sotomayor from New York, who's been on the Second Circuit Court of Appeals, District Court Judge. And let's go back to Barack Obama, and then we'll come to our guest, Stephen Presser, where he said, Barack Obama said to Berkowitz, but here's my point, Jeff. I do think the U.S. Senate has an important role in advising consent, and it's perfectly appropriate for a senator to oppose a nominee to the Supreme Court, even if they're smart, even if they're nice, if their fundamental vision of the Constitution is flawed. So I turn to you, Professor Stephen Presser. Is the fundamental vision of the Constitution of Judge Sonia Sotomayor, is it flawed?
I think it may be. One of the sad things, Jeff, is we really don't know much about her constitutional philosophy. We've heard her say things like a Latina woman would be a better justice than a white male who hasn't lived that life. Those are her words. We've also heard her say, I think at Berkeley a while back, that it's the job of the judge to make policy. Then she said, whoops, I shouldn't have said that. And so that if that's her philosophy of judging, it's a little different from what you and I were taught in law school.
What was that? Judges supposed to be, they take an oath of impartiality.
Well, they take an oath to uphold the Constitution, not to rewrite it.
Okay.
And what we want to know is she somebody who's comfortable with that, let's call it very conservative task, or is she somebody who wants to rewrite the document?
The document being this, I just pulled it out of my pocket, is my pocket Constitution. We get this at the University of Chicago Law School because when I was there, I don't know if it's still the case, but when I was there, they take the Constitution very seriously. And Dean Gerhardt Casper said, you know, it's kind of like your American Express card. People plug for American Express. Don't leave home without it, right? Keep it right there. Do you got a Constitution plugged in right there in your pocket?
No, alas. Well, I have the internet on my phone. I can find it.
You can find it, okay, but you don't keep it right there.
But I don't carry it around with me.
But it's an amazing document, right?
Oh, it is.
How many pages? What, 27 pages, something like that?
I think it's
short pages.
It's very short, and you could almost memorize it.
So this, you're saying, is supposed to be vital when a nominee to the Supreme Court thinks about how they make their decisions, and you're saying they don't make policy, appellate court justices don't, appellate court judges in the Second Circuit, according to you, Professor Stephen Presser, they don't make policy?
Well, according to all the orthodox documents of our tradition, they don't. Now, the sad thing is, as you and I both know, for the last 30 or 40 years, they have. And in fact, the parties now take starkly different positions on this. The Republicans, as long as we can remember, have said it's the job of a judge to judge, not to legislate. And the Democrats have said, no, 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 we want judges with empathy, who can help adopt the Constitution to the times, who can deal with a living Constitution. And I think it's at Chicago. I don't know if you ever had Krosky, probably a little bit before your time.
Yeah, I've read. I mean, the name sounds familiar.
Remember, he said, there is no such thing as a living document. It just doesn't happen.
It doesn't. He's never met a living document.
That's right.
It's like sometimes lawyers who practice law know they go to depositions, and there's often an objection, and the party being deposed, the lawyer for the party being deposed will say, objection, the document speaks for itself. The wise comeback is, I never met a speaking document.
There you
Kind
go.
of like a living document, right?
Exactly the same thing.
All right, but seriously, you know, this woman, and I don't mean that in denigrating way, she is a woman, she is a female, she is a Latina. She has had a rich life. I mean, you're not going to dispute that. She has had, as she said, a wise Latina woman with the richness of her experiences. That's her. That is Judge Sonia Sotomayor, right?
She's done some very impressive things. I mean, to be raised by a single mother, to have been a summa at Yale, to be a summa at Princeton and to go on the Yale Law Journal. All of these are impressive things. But what we don't know, strangely enough, here's a lady who's been on the Court of Appeals for 18 years, and almost
not Court of Appeals for 18 years, in the federal courts.
In the federal courts for 18 years.
District court judge for 8 or 9 years.
That's a very good point.
And then 8 or 9 years.
But 18 years on the bench, and I don't know about you, Jeff, but I haven't heard anybody who can point to a single distinguished sentence that this lady has written. Now, there ought to be some out there, and maybe we'll see more, but that has to lead you to raise an eyebrow. I mean, is this really a first-class thinker, or is this a Harriet Miers with a more colorful background?
And Harriet Miers, of course, was somebody who worked in the White House counsel. President Bush nominated her for a brief period before the conservatives really pushed him to come up with somebody with more intellectual firepower. He did, and that would be Judge Roberts, right?
That's right.
Now is Chief Justice of the Supreme Court.
Followed by Judge Alito, who was equally distinguished.
So you're acknowledging Harriet Miers would have been a mistake. She didn't have the firepower, or so it seemed from the brief period we
It's a nice question whether it would have been a mistake. She had some firsts, too. I mean, she was the first president of the Texas Bar Association and the first woman to be partner of a Texas law firm, but not a distinguished jurisprudential scholar.
Yeah, I mean, I'm reaching for, as a reminder, the list of who is on the court now. Let's just shift to that a little bit, because the question is, what impact does Judge Sotomayor have if she gets on the court? And some would say, well, no impact, because she's liberal. She's replacing David Souter, who was appointed by Republican George Herbert Walker Bush and was thought to be a conservative. He wasn't. So no change.
I think that's basically right. With regard to substantive outcomes, what is a change is that this appointment, in a way, is more nakedly political than those we've seen recently. I mean,
nakedly political.
Nakedly political. You said you wanted to talk about politics, and
well, only if it's relevant. I mean, you're not making that up. You're saying this appointment by Barack Obama, the 44th President of the United States, the first African-American president of the Harvard Law Review. You went to Harvard as an undergrad in law school.
And was not on the Law Review either.
So you've got a bond with Barack Obama.
That's right.
To that extent. And the first African-American president of the United States. You're saying first time he gets to appoint a Supreme Court justice, he makes a nakedly political appointment?
That's right.
Can you back that up?
Well, what I mean by that is he's chosen this woman, as near as I can tell, because of two ascriptive criteria. She's a woman and she's a Hispanic. There were women, I think, who would have been better justices. I can think of at least one Hispanic who I think would have been a bit of a more distinguished appointment. But he's got a twofer here, and that strikes me as a political calculation.
Who's a woman who would have been a better appointment?
Well, Diane Wood, who was his colleague at the University of Chicago, who's on the Seventh Circuit now. Pam Carlin at Stanford. Kathleen Sullivan also at Stanford, I think.
Both, I think, openly gay. So that would have been a twofer. I hope they're openly gay, because if not, I've just outed them.
I've heard the same thing. I don't know Alina Kagan's orientation, but she would have been an interesting choice as well. Right. The former dean of Harvard, now the Solicitor General.
And why would those three women lawyers, female lawyers? Why would they have been better nominees?
I think the three of them are deeper jurisprudential thinkers whose scholarship has impressed even those of us on the right. I can't say that with regard to Ms. Sotomayor because I haven't seen that kind of evidence of deep thought.
Well, but is it somewhat unfair because Carlin, Sullivan, Kagan have not been sitting on the court. Carlin and Sullivan have been at the Stanford Law School where you get a lot of chance to show some flair or write law review articles, which I assume they've been doing, other articles. Kagan, I think, now Solicitor General, Dean of the Harvard Law School, again, get a chance to show some flair. They haven't been on the bench. So is that an unfair comparison?
In a way, yes. And I think your point is a good one. But again, when you're on the bench for 18 years, Court of Appeals and District Court, you do have an opportunity to write. And no one has pointed to anything to say, wow, this is an impressive piece of scholarship.
And so people are saying, this has been anonymous comments that came out about her from her clerks. You could understand why they'd be anonymous because clerks don't want to go on the record.
Yeah.
And they kind of implied she just doesn't have, what you say, as much firepower. Some of her colleagues who commented, I think this is anonymous, maybe not, judges saying she tends to be aggressive, which is fine, and questioning, but they wonder if sometimes she's really engaged and absorbing what's being said by the lawyers arguing as opposed to just making points. Have you heard those things?
Well, we have this really unusual piece, you probably have read it, by Jeff Rosen, the legal affairs editor for the New Republic. And it was almost like a preemptive strike, sort of warning the president, don't appoint this lady.
Because of the things I've just raised and Rosen raised. Yeah.
Because she's not really first rate and because the lawyers who appear before her say she's a bully. I mean, those are the things that were in that
And Rosen's
piece.
a liberal, as I understand.
And Rosen is a liberal.
So Rosen thinks she's not the best person to advance the cause. So it comes back again, think about the composition of the court right now on the conservative side. John Roberts, appointed by Bush, the now Chief Justice. Scalia, appointed by Reagan. Alito, appointed by Bush. Those three people generally refer to, especially Scalia and Roberts, and perhaps Alito, being really bright, having written. Alito was on the appellate court before. Roberts argued many cases in the Supreme Court. So they had a track record of showing smarts.
That's right.
Scalia at the University of Chicago Law School, other law schools, and then since as a writer on the court, he may be a bit of an intellectual bully, but he's a tough guy intellectually.
He is.
So liberals were looking. Now, some liberals would say Clarence Thomas is not up to those folks. He was appointed by Bush. Some would say he's certainly done better. He did not have a.
Do you want to talk about Clarence Thomas? I think he is a heavyweight.
Is he? But he did not have a distinguished record when he was nominated by George Bush in '91.
He'd been on the Court of Appeals, I think, for
short
slightly more than a year.
Yeah.
But he was at the EEOC, and he had written some very impressive speeches and had some interesting things to say about natural law.
So you put him in there with Robert, Scalia, and Alito.
I put him in there as an interesting thinker and as somebody who's made, I think, powerful contributions to jurisprudence. Now, maybe...
And then just let me... Oh, go ahead.
Sure. I was just going to say, maybe that will happen with Ms. Sotomayor when
we
she
haven't
goes
seen
on the
it
court.
yet, is what you're saying. And
But
you
we
saw
haven't
that
seen it
before with Thomas as your argument.
You did.
And then there is Kennedy, who's now really the swing vote, a Reagan appointee, and some would say he's the lightweight among the conservatives. Is that right? Was a lightweight when he came on there. Bork got borked. Reagan went for a safe pick. He went to Kennedy, and that's it.
I would not be able
right?
to mount a strong case against that suggestion.
Okay. So, but what liberals would argue, who are supportive of Barack Obama, they wanted some intellectual heft because as you go below the line, so to speak, that's the line between majority and minority, the liberals now, David Souter, who Sotomayor is replacing, Ruth Bader Ginsburg, appointed by Clinton, competent, but I don't know that she's distinguished herself, has she?
I think so. I mean,
she
has some very interesting theories, and she is a good writer and a profound thinker. I don't agree with a lot of the things that she says.
But is she a strong intellectual counterweight to Scalia and Roberts and so forth?
I don't know. They're very. I mean, remember that Scalia was a huge fan of Ruth Bader Ginsburg.
Okay. So Ginsburg, you're saying, is up there. Breyer, is he another Clinton appointee?
He was my teacher at Harvard long
So what are you going to say? Is Breyer up there with the intellectual heft of the conservatives?
Yeah, Breyer's written some very
so according to you,
they've
got Ginsburg, they've got Breyer, John Paul Stevens,
A distinguished graduate of Northwestern Law School.
appointee by Ford, turned out to be a devout liberal
Yeah.
over the years.
It was a
Is
bit
he
of
up
a
there with
surprise.
intellectual heft, even as a liberal? I
He's
shouldn't
a-
say even, but as a liberal.
I think he's more of a pragmatist
Okay.
than an intellectual.
So, but still, even if you're right that Ginsburg and Breyer are intellectually strong, you want somebody to give them a third or fourth or something.
Well,
And you're saying liberals are not sure that Sotomayor is up to the fight.
that's the thrust of Jeffrey Rosen's rather surprising piece.
All right. The Ritchie case.
Sure.
Let's get into substance.
Okay,
Here's a case: reverse discrimination. Firefighters out of New Haven, right?
that's right.
The African Americans take the test, Hispanics take the test, whites take the test. All but one of the people who pass are white, right? Most of the minorities
That's correct.
fail.
The ones who would qualify for promotion were all white with the exception of one Hispanic, no blacks.
Yeah, and so New Haven says, "Oh, we're going to get sued. We'll just throw out the test. Nobody gets what the promotion, right?"
That's correct.
And the trial court upholds that decision. They say this is okay. There's no violation of law here, right?
That's exactly right.
And then it comes before Judge Sotomayor and two of her colleagues on the Second Circuit, and they do what?
They would have affirmed the lower court decision that there's no case, but they would have done so without opinion.
Perfunctory thing. It's kind of unusual for an appellate court to decide that way. They usually write an opinion, right?
Normally, yes.
You think they were just busy that afternoon? They wanted to go see a ball game? They had a date? I don't know what.
I don't want to speculate, but
We'll go ahead and speculate. That's what we do. It's
All right.
politics on the show.
What we
Go
do
speculate.
know is that one of their colleagues, Jose Cabranes, I hope that's
Right.
how you pronounce his name, a Clinton appointee and a judge, I think, who's very well respected, said this is terrible. This is an important constitutional issue. It shouldn't be brushed off without an opinion. We should hear it. And the case is now before the Supreme Court, and they will rule on whether it was permissible for the city to do what it did before Judge Sotomayor gets confirmed. So we'll have an interesting Supreme Court opinion that may well reverse the stand she took.
And so she'll be questioned about that at length and why
I
she didn't
think
even
so.
take the pains to write an opinion, or
I
at least
think so.
urge her colleagues to do so.
Now, to be fair to her, you could have disposed of the case on procedural grounds, and I think that's what they tried to do without addressing the substance of it, that the city has discretion here and we don't really have the right to intervene. I think that's incorrect, but they could have done that.
Substance comes back to this document here, the Constitution. It comes back to the Fifth Amendment. Is the Fifth Amendment, nor shall any state deprive any person of life, liberty, or property without due process of law?
Well,
right?
conceivably, it's the 14th Amendment equal protection argument.
Nor denied to any person the equal protection of the laws, 14th
Exactly.
Amendment.
What we've got here is racial discrimination, pure and simple, that you throw out the promotions because there are no blacks in the group. And if you're supposed to have a colorblind constitution, if that's what that means, then we've got a real problem there.
So it gets back again to, you just said colorblind, it gets back to her statement as a Latina, rich experiences, she will more often than not reach a better conclusion than a white male who hasn't lived that life, right?
That's what she said.
So it gets back to that.
That's what she said.
You said that in Berkeley in 2001, right?
Yes, and I think she published an article with the same statement.
And it was careful comments. These were prepared comments. She not only said that, but she wrote it out before.
That's
It's
right.
there on the New York Times, hardly a right-wing journal for you to find.
That's right.
This is troubling.
It is troubling. But
What about Limbaugh? He says she's a reverse racist. Is that too strong?
I'm not sure I would want to label it, but what we do know is it suggests that there are different constitutions for white people, for Hispanics, for black people. And I
Only
don't
one.
think there should
There's
be.
only one. Here, see? I got this. This is the only one. You go to your store anywhere, say, I want the Constitution of the United States. They won't say, oh, do you want the white Constitution? Do you want the black Constitution? Do you want the Hispanic? They'll just give you one, right?
That's right.
It's an important point. What about Obama? He's sort of walking back this, and the press secretary, Robert Gibbs, they're kind of walking it back. They're saying, you know, if you look at the whole speech, you look at her whole comments, the whole piece, you know this woman, she didn't mean that.
She did. If you
She
look
did?
at the whole
You know
piece,
that- you know
well,
the
if you
piece?
look at the whole piece, it's even stronger. I mean, the suggestion is
But you've never met her. You've never talked to her.
no. I
Barack
never-
Obama, we're pretty sure to spend hours with her, right?
well,
He's interviewed her. He's talked with her. He would make this kind of
we
appointment.
know he's spoken with her, and what's more, we know that she epitomizes the kind of jurisprudence that he's recently spoken in favor of. I mean, his word is empathy. He wants an empathetic justice, and he said what that means is, I want somebody who understands what it's like to be a single mother, to be a member of a minority, to be an outsider.
He said that recently.
Yeah.
But and before, when he was voting on Roberts as a U.S. Senator, on Judge Roberts, he voted no. And he voted no because he said he didn't have heart, essentially, right?
Something like that.
And then same thing with Alito, right?
That's right.
Those guys never supported the plaintiffs. They never supported the people. They always supported corporations.
That's what he said. He thought they were too cozy with powerful interests.
What about you, Stephen Presser, Professor Presser?
Am I cozy with powerful interests?
Yeah. Do you have heart, or do you generally, when you look at these things, do you side with the little guy, the downtrodden, or do you side with the corporations?
You try to side with this document that you've been banging.
Is that pretty much what comes up? Give people an idea. What comes up to the Supreme Court? There's this word cert-worthy, right?
Certiorari?
Yeah, you get certiorari because there's a split among the circuits. Supreme Court.
Right.
What else goes to the Supreme Court?
Major cases involving interpretations of the Bill of Rights or involving interpretations of the 14th Amendment.
This document.
That
Major
document.
disputes about this document, they go to the Supremes, right, as we say.
That's the idea.
When the Supremes get it, they are the law of the land, they are the final word. They're supposed to focus on this document.
They take an oath to uphold it.
What are you saying? You're saying Obama doesn't focus on this document?
I'm suggesting that he has other things in mind.
He taught at the University of Chicago Law School. He would say he taught common law. We said that people sometimes dispute that, say, well, he taught due process, equal protection. No, folks, he taught common law. Maybe he didn't teach the exact course. Maybe Stephen Presser didn't teach that exact course. But they are constitutional law scholars. Stephen Presser has written a textbook on common law, right?
I have a casebook with
one of Obama's buddies.
With my colleague Doug Kamek, who has endorsed
a conservative who flipped and endorsed him, right?
Yes, he did.
Pro-lifer, right?
A surprising move, yeah, because the president is not exactly pro-life.
Okay, so Obama is a common law professor at a point in his life when he taught the University of Chicago Law School.
Correct.
You are. You're saying Barack does not believe in the U.S. Constitution?
He believes in a living Constitution.
Changing Constitution. It's got to change over time. We're taking this in May 31st, 2009. Is this thing different? When was this written? When was this Constitution written?
Parts of it in 1787, amendments as recently as a few years back.
Okay, but so good parts of it were written over 200 years ago.
That's right.
Don't you have to do some changes over time?
Yes, you do, and that's what Article 5 is all about. It
Amending
provides a process to amend it. But the question is, should judges amend it?
Should judges, in interpreting, they have to adapt to, there are things we didn't talk about the internet back in the 18th century, right?
That's right.
We have internet questions that come up for the Constitution. You see the point? You've got to be adapting, don't you? Is that any different from saying you got a living document?
The idea of adopting the Constitution is no different from the idea of a living document. The question is
from adapting the Constitution to the changes.
Do you do it through the amendment process? Do you do it by legislation? Do you do it by the popular branches? Or do you let the judges, who aren't even elected, rewrite the document?
So you're an originalist.
Yes.
Your view, this is the meaning, look in the Constitution, what did they intend? Interpret the Constitution,
how do they
apply
understand the words? That's right.
You're saying Obama's not an originalist.
I don't think he would say he is. No.
He says use this document to start with, but you got to view the fact that it's a living document. That's
right.
Sotomayor, she's a living document type person.
So.
You think so?
We think so.
If you find that, and you were in the Senate, they vote on confirmation, would you vote no?
Yeah,
I'd
vote no on that alone.
And Barack said that in point right here. He said, if your view of the Constitution is fundamentally flawed and you're up for confirmation, he would say vote against, right?
That's correct.
At that time, he went on to talk about civil liberties and so forth, civil rights. If a judge doesn't have an understanding of this thing, he'd vote against.
That's what he said.
What's the analog here for the Republican senators? Give them advice. What would they do to vote against this person? It's not going to be that she doesn't have enough view and faith in civil liberties. She'll do that. It's not going to be that she doesn't believe in civil rights. She does that. What's the problem area here?
You've stated it very, very nicely. The problem area is, are you going to uphold the Constitution or are you going to rewrite it?
Okay. And you're saying, from what you've seen so far, very likely she's going to rewrite it.
It's a concern. Now, to be fair to her, she has said on several occasions, it's not the job of a judge to do that. It's the job of a judge to follow the law that's laid down. The problem is that they're contradictory statements, and it would be important to learn, what does she really believe? But there's another thing too, Jeff, and this one I advance a little bit more tentatively. But when you appoint somebody to the Supreme Court, I mean, you're appointing them to the highest place for a judicial figure in the land, and you want a first-class mind if you can get one. And I'd like to know more about whether she has that or not. When Alito,
how do you know that? What kind of questions would you ask? Say you were in the Senate. And folks, just so you know, by this document, the Constitution, it lays out that the Senate shall be the entity who decide. President makes the nominations and appointments to the Supreme Court. The Senate decides. They will do that in July. It'll take a majority to confirm her. You're advising a senator to grill her and find out if she's got, what did you say, sharp mind?
A sharp, whether she has the jurisprudential depth that you want folks on the Supreme Court to have.
The intellectual heft.
That would be a good way to describe it.
How are they going to find out?
Well, one thing that I would like to know that I don't, there are an amazing number of things that we don't know right now. Remember when Alito was nominated, I think 19 of his colleagues or something paraded up to the Hill and talked about what a fine judge he was. I'd like to hear more about that for her. I haven't.
From her colleagues on the Second Circuit.
And from lawyers who've appeared before. That was the extraordinary
But they'll say that. You can find people, I'm sure. You're not going to get this far. If you got Judge Sotomayor in the chair, I'm Judge Sotomayor, grill me. Come on, give it to me.
What do I want to know?
Yeah.
What do you think your job as a justice is?
Is to apply the law and the Constitution judiciously.
What does that mean, judiciously? Does that mean with empathy, or does it mean according to the manner in which it was understood when the document was drafted?
Well, of course we use our experiences, so of course we empathize, of course we look at the Constitution and see what it says, and of course we have an understanding of what people intended when they wrote this.
And which is it?
It's all of that.
It is?
It is all of that.
And where have you seen in our tradition that it's all of that?
In the vast reaches, and go back to Brown v. Board of Education. Do you think those folks didn't have empathy with African Americans who had been discriminated against and were treated as second-class citizens when it came to going to school? Do you think that?
Is that?
Tell me that, Professor Presser. Do you think that?
Do I think Brown is an empathetic decision?
Yes.
Yeah, I think it probably is.
And we're going to continue to speak as the credits roll, but I very much want to thank our guest, Professor Stephen Presser from the Northwestern University Law School. He is the Raoul Berger legal history scholar, right?
Something like that.
Something like that. Okay. He's got the endowed chair there. He teaches at the law school, teaches in the business school. He also holds an appointment in the history department. Okay. Continue the grilling of Judge Sotomayor.
So that is every case like Brown versus Board of Education? Is that what you mean?
I think often the cases require some empathy. Often it's
How
a tax
often?
matter in which there's not a lot of room for empathy. There's a lot of room for looking at the law, looking at the Constitution, and doing the best you can to come up with a decision that is consistent with the Constitution and applies the Constitution.
But not necessarily consistent. That's
No,
interesting.
we always have to be consistent with the Constitution.
Huh.
Did I pass?
I'm not sure.
You don't know. You're going to have to go back and decide.
I want to talk to your colleagues.
All right. So, national security. What are they going to grill her on the national security? She hasn't written a lot of.
No, we don't know anything about it.
So what would you want to know? I'm Judge Sotomayor. Ask me a question. Any question?
What kind of discretion do you think the president has with regard to his national security authority to make war?
Well, the Constitution says is that Congress should declare war, right?
It does, yes.
So I don't think the president has any. He has to do what George Bush did. He came to the Congress. He asked for authorization to tell military action in Iraq. They gave it.